done was protected by the First Amendment. In Falwell, the court decided that pornographic material is not protected by the First Amendment. Well, that's wrong in many ways. I mean, pornography is not a category of speech that anybody knows what it is. It's simply the word that we use for sexually titillating speech. And nothing about the Hustler caricature of Falwell was in any way pornographic. It did not appeal to the interest in sexual arousal, the prurient interest in any way. And generally, pornography is protected, as any other speech is. Most recently, what we looked at was the American Booksellers case, where you're dealing with pornography, sexually titillating material, which nonetheless is protected by the First Amendment, at least where the government is trying to do viewpoint discrimination, outlawing the kind of pornography that it disfavors while allowing raw, rough, ready sex as long as it treats women equally. Finally, the court decided that no prior restraint could be issued to enjoin the ad parody. Enjoin means stop it, order that it can't be published. Well, Falwell did not seek a prior restraint. It was not in any way a prior restraint case. But a good answer would say, not only that it was not an issue in the case at all, but that had Falwell attempted to get a prior restraint, he would clearly have lost, because he wouldn't have been able to show that publication would inflict grave, immediate, irreparable harm on the national security or on some other important government interest, as opposed to his hurt feelings. And then look at some of the true false questions. I'm trying to save time for your question. We'll buzz through these quickly. A public official or a public figure who sues for libel must prove that the publisher acted with ill will or intent to defame. True or false? All right? Clearly false, right? We just went over that. I mean, I've used that question so many times in one form or another, and it's baffling to me that people say, oh, that's a true statement, because ill will and intent to defame are not elements of the libel tort, and they're not required in order to prove actual malice. Every libel plaintiff has to prove that the defamatory statement was of and concerning the plaintiff. True? Yes. A limited purpose or vortex public figure, unlike a pervasive public figure, is not required to prove actual malice or constitutional fault in a libel case. True? False? False. If you're a public figure, you have that burden of proof, whether you are all-purpose, pervasive, or limited purpose. And it's exactly the same burden of proof that the public official has. Public officials and all public figures must prove constitutional fault. Knowing? Also for involuntary. A television station that airs a false and defamatory statement about a public figure without conducting any investigation at all has the burden of proving truth. Not so. Not now. Not now. The burden of proving falsity post-Sullivan is on the plaintiff. And the fact that they didn't conduct any investigation at all may be relevant to actual malice, if the case comes to that. But the burden of proving truth, falsity lies on the plaintiff, not truth on the defendant. Under the First Amendment, a blogger's advocacy of violent overthrow of the government is protected so long as it can't be considered incitement to imminent lawless action. True, that's Brandenburg. Okay, now, what questions have you been saving up that we should deal with? Going? Say again? Open notes? No. No. Yeah, for sure. I've tried that. It doesn't work very well. I've tried open books. I've tried take-homes. They don't really work very well. You can bring, as I said on BSpace, you can bring a sheet of blank scratch paper if you want to try out some of your written answers so that they don't look terrible. They don't have arrows and see down below kind of things that I can't read. You can bring a piece of scratch paper, but no notes, no books, no computers, no cell phones. You know? Paper. There won't be anything about the Supreme Court argument in Alvarez on the test. What you just said sounds good to me, that the court is reluctant to have scales or spectrums or whatever of speech that is of slight value and speech that is of great value, recognizing that in Citizens United, they're talking about core political speech. And if there's anything that is most protected under the First Amendment, that's it. But in fact, depictions of animal cruelty are protected speech, so is core political speech. Okay?
Can you go over how you said the Supreme Court Citizens United and it's asserted like a judicial restraint? Can you go over what ways they did that?
In Citizens United? Well, let's see if I can remember. They took a case in which Citizens United, the nonprofit corporation that wanted to air the documentary attacking Hillary Clinton, in which that corporation has said that this campaign finance law doesn't apply to us, doesn't apply to this kind of documentary at all. And if we're wrong, then the statute, as applied to us, violates the First Amendment. And the corporation expressly told the lower court, we are not attacking the statute on its face, that is, in all of its applications. The court then heard oral argument on it, and didn't get it decided in the previous term. They set it for a special re-argument and invited the parties to brief, tell the court, whether it should overrule two previous cases, two precedents that seemed to favor the government side of the case, allowing restrictions on corporate spending in elections, and then ended up with a decision that overruled those cases, that held that the statute was unconstitutional on its face, something that the party hadn't argued, and dispatched all of the more narrow grounds on which they could have decided the case in the corporation's favor. So it was the most dramatic example of judicial activism that I can remember. right up there with Bush versus Gore when they gave the presidency to George Bush. Yeah, the two ideas are related, that is judicial restraint and originalism. In this way, the originalists say we should interpret the Constitution by its text first, see if the text answers the question, and if it doesn't, we should interpret it according to what the framers understood it to mean. And that limits what the court can do 2 centuries later, coming uncoupled from the original understanding and based on their own values or the values of the time, which is a much more activist way of deciding cases, where judges are not trying to figure out what the intent was 200 years ago, they're trying to figure out what the correct policy today is. Well, that allows much more scope for judicial activism than an originalist approach does. Yeah. No, you don't even know the names of the justices. No, it wasn't originally in the Clark case, but that was a good distillation of what those principles are. I think Clark followed the draft burning cases, which had originally announced that. Anything else? No? Tina?
Other than all the other implications, the actual holding of Citizens United is that corporations can, in fact, spend their money on political electioneering in the run-up to election and up to an election, right? They've chosen to funnel that money into super PACs instead.
But they what?
But they've chosen to funnel that money into super PACs.
Well, that's not part of the holding of Citizens United. What they've done subsequent to the decision, I mean, some smart lawyers sat down and looked at Citizens United, it says that restrictions on corporate spending in elections are gone, and said, well, geez, why don't we make something called a super PAC? There weren't any before Citizens United. Now there are.
If the whole law was thrown out, what is keeping corporations from directly contributing to?
Because that's a different part of the law. The one that prohibits corporations from contributing directly to political candidates is a different law. You may question its continuing vitality after Citizens United, but the court hasn't invalidated that old one. Aaron?
So Paul tells us that a public figure can't sue for injury from published material without the false statement of fact.
Made with actual malice.
So if that's the case for a public figure, then how is it different for a private figure? So do they have
I don't know. I would argue that it would be the same. It's just that it may not have to be an actual malice showing. It could be a negligence showing. Ariel?
What role did the 14th Amendment play?
In which? None. How would the 14th Amendment apply there?
There's more your question right
It was? How does the 14th Amendment apply to Citizens United? Because it's a purely federal case. It was a federal law. There's no states involved. And the function of the 14th Amendment due process clause was to apply First Amendment rules to the states. But there was no need to do that in Citizens United because it was a federal restriction. Yes. They were protected by the fair court privilege. The documents? No. The documents, well, the affidavits that they relied on, that the National Enquirer relied on, were filed in the New York Family Court proceeding. And that made them fair game for recording, even though that proceeding was supposed to be private, secret, confidential. Okay, see you Thursday.